Imagine a law that gives one man the power to walk into your home, take your child, and leave. No court order, no evidence of neglect, no parental consent. Not in secret, in broad daylight, with the full backing of the government. This law existed. It ran for 60 years. Across every state and every territory of a modern democracy. And the man who designed it didn't hide his reasons. He stood at a national conference and said them out loud. His name was A.O. Neville, Chief Protector of Aborigines, Western Australia. And in 1937, his question to the room was this: Are we going to have a population of 1 million blacks in the Commonwealth? Or are we going to merge them into our white community and eventually forget that there were any Aborigines in Australia? That's a direct quote from an official government conference, recorded in the minutes. He wasn't hiding. He was presenting a plan. If your family tree has an unexplained gap in Australia, a grandparent raised in a government home, a great-aunt sent to a mission, a relative whose birth name doesn't match the record, you may already be inside this story. What makes this case different from any other child removal program I've investigated is not that it happened. It's that the policy was stated openly, in law, in government conferences, and in published reports. The last children were taken in the 1970s. This wasn't a failure of the system. It was the system working exactly as designed. The official explanation was protection. Governments called it protection. Some people inside the system genuinely believed it. Missionaries who thought they were providing education. Social workers who thought they were offering a better life. I don't dispute their individual sincerity, but the laws gave them something far broader than protection. And once you read those laws, the word starts to collapse. Because the laws didn't say protect, they said absorb. The Aborigines Protection Amending Act, No. 2 of 1915, New South Wales. Section 13A. I'll read it exactly as written. The board may assume full control and custody of the child of any Aborigine if, after due inquiry, it is satisfied that such a course is in the interest of the moral and physical welfare of such child. The board may thereupon remove such child to such control and care as it thinks best. Those are the exact words. Due inquiry meant whatever the board decided it meant. No court, no judge, no appeal process for the parents. The board decided. The board removed. The parents were told nothing. Or they were told the child had died. And this wasn't one state. This was national. The Aboriginals Ordinance Act, 1911, Northern Territory. It made the Chief Protector the legal guardian of every Aboriginal child in the territory. Every child, regardless of whether the parents were alive, regardless of whether the family was intact. One man, guardian of all of them. And this is where the story changes. Because the documents don't just permit this, they explain why. A.O. Neville wrote it down in an official report. Every endeavor is being made to breed out the color by elevating female half-castes to the white standard, with a view to their absorption by mating into the white population. He published that, under his own name, in his role as Chief Protector. At the same 1937 conference, he said something else. In Western Australia, we have power under the Act to take any child from its mother at any stage of its life, no matter whether the mother be legally married or not. The conference passed a resolution. I'll read it. The destiny of the natives of Aboriginal origin, but not of the full blood, lies in their ultimate absorption by the people of the Commonwealth, and it therefore recommends that all efforts be directed to that end. That was the national position, adopted by every state representative present in 1937. The same year, Hitler's government was implementing the Nuremberg Laws. Australia was building a state-backed assimilation project around child removal, guardianship laws, and the idea of breeding out Aboriginality, using children. Then the story stops being legislative and becomes personal. His name was Archie Roach, born in 1956 in Mooroopna, Victoria, Gunditj Mara and Bundjalung people. He was taken from his family when he was 2 or 3 years old, placed in an orphanage, then moved to foster care, then moved again. His foster parents were white. They raised him. They told him his biological parents were dead, both of them dead. He grew up believing he had no family, no people, no history before the orphanage. When he was a teenager, a letter arrived from a sister he didn't know he had. The letter told him his mother had just died. His mother, the woman he'd been told was already dead. She had been alive the entire time, looking for him. He later described the moment. The realization that the people who raised him had been given a child whose identity had been erased. That somewhere a mother had spent years not knowing where her son was. That the system hadn't saved him from anything. It had taken him from everyone. Archie Roach wrote a song about it. He called it "Took the Children Away." It became the anthem of the stolen generations. It won an ARIA award in 1991. It was played in Parliament. He died in 2022. He never fully recovered the childhood that had been filed away before he could remember it. But he left testimony. And he wasn't alone. By 1997, there were over 500. The 1997 report changed everything. It was called Bringing Them Home, the Human Rights and Equal Opportunity Commission, the national inquiry into the separation of Aboriginal and Torres Strait Islander children from their families. 680 pages. The findings were unambiguous. The report stated, "Not one Indigenous family has escaped the effects of forcible removal. Not one family. Across the entire continent. Across 6 decades. Children were taken at birth, at infancy, at age 5, 7, 12. Some were told their parents were dead. Some parents were told their children had died. Mothers who fought back were threatened with imprisonment. Fathers who resisted were removed from communities. The children were sent to institutions, government homes, church missions. One of them was Kinchela Aboriginal Boys Training Home in New South Wales. Boys there were given English names, forbidden from speaking their languages, punished for using their own words. Their hair was cut. Their skin was scrubbed. They were trained for manual labor. The Bringing Them Home report documented physical abuse, sexual abuse, and psychological abuse at Kinchela and institutions like it across every state and territory. And here's what nobody explains. Most of these institutions kept records. But when survivors or their families tried to access those records, many were incomplete, misfiled, destroyed. or simply sealed. The disturbing part isn't that the evidence is hard to find. It's that so much of it was stated plainly, in law, in official reports, and in government proceedings, that the real difficulty is explaining why none of it is common knowledge. The Chief Protector said the goal was to breed out the color. He said it at a national conference. The conference agreed. The law was written. The children were taken. The institutions were built. The records were kept. The survivors testified. A 680-page federal report confirmed everything. And still, outside Australia, this history rarely appears in standard curricula or mainstream historical coverage. But the official story is always the explanation. The real story is in who benefited. Government institutions received funding per child. More children meant more funding. Church missions received land grants and subsidies for taking Aboriginal children. And the children themselves? They provided labor. Girls were trained at Cootamundra Domestic Training Home specifically to be placed as servants in white households. Boys at Kinchela were trained for station work. The system didn't just separate families. It produced a workforce. And when they aged out, no savings, no wages held in trust, no land, no family to return to. Many didn't know where they came from. Remove the child, erase the identity, extract the labor, release them with nothing. And when they struggled, use their struggle as evidence that Aboriginal people couldn't manage their own lives. The cycle was profitable, and it was designed to be. But profitable systems don't collapse on their own. So how did this one survive 8 decades without a single structural challenge? Look at how it unfolded. 1869, the first law, Victoria. By 1905, Western Australia had its own version, and A.O. Neville was eventually appointed Chief Protector under it. By 1911, one man in the Northern Territory was the legal guardian of every Aboriginal child. By 1915, New South Wales didn't even require a court order. By 1937, every state agreed at a national conference. Absorption was the goal. Then watch the language shift. 1951, the policy is officially renamed assimilation. Same mechanics, different word. 1969, New South Wales repeals its Protection Act, but removals continue under general child welfare laws. The 1970s, the last forced removals under explicitly racial legislation. 1997, Bringing Them Home is published. 2008, the National Apology. 8 decades of policy. One unbroken logic. The word changed 5 times. The mechanism didn't change once. But there's one document that changes everything. And it was published after Nuremberg. A.O. Neville published a book in 1947. The title was Australia's Coloured Minority, Its Place in the Community. In it, he included charts, generational charts, showing how over 3 to 4 generations of controlled mating, dark skin would progressively disappear. He drew diagrams of human beings becoming lighter, like a color swatch fading to white. He published that after the war, after the world had seen where racial science leads. He published his charts of disappearing color. and his ideas remained within Australia's official assimilation framework, unchallenged. Australia apologized. It took until 2008. And here's what the apology did and didn't do. The national apology happened on February 13, 2008. Prime Minister Kevin Rudd stood in Parliament. The public galleries were full. Survivors were present. Some had waited their entire lives. He said, "To the stolen generations, I say the following. As Prime Minister of Australia, I am sorry. On behalf of the Government of Australia, I am sorry. On behalf of the Parliament of Australia, I am sorry." He said, "To the mothers and fathers, the brothers and sisters, for the breaking up of families and communities, we say sorry." He said, "For the pain, suffering, and hurt of these stolen generations, their descendants, and for their families left behind, we say sorry." It was the first time the word had been spoken officially by the head of government in Parliament after decades of refusal by previous prime ministers. Australia apologized. But here's what it didn't do. The apology happened in 2008. Compensation? That's a different story. As of 2025, there is no single national reparations scheme. Redress is handled state by state. Victoria offers a one-time payment of $100,000. Western Australia announced $85,000 per survivor in 2025. Queensland, where some of the most extensive removals occurred, has not implemented any dedicated redress scheme at all. Many survivors are now in their 70s and 80s. Some have died waiting. The Bringing Them Home report recommended compensation in 1997. It is now 2026. But here's the number that should disturb you most. As of June 2024, approximately 20,000 Aboriginal and Torres Strait Islander children are in out-of-home care in Australia. Aboriginal children are 11 times more likely to be removed from their families than non-Indigenous children. 11 times. The rate is not decreasing. It is classified by the Australian government's own Productivity Commission as worsening. The national target, Closing the Gap Target 12, aims to reduce Aboriginal child removal by 45% by 2031. Australia is not on track. The gap is widening. The policy was called protection in 1869. It was called absorption in 1937. It was called assimilation in 1951. It was called child welfare in 1970. It is called out-of-home care in 2025. The word changes. The overrepresentation doesn't. Archie Roach spent decades looking for his family. He found some of them, not all. His mother died before they could meet again. His song plays in schools now, in the same country that took him. The Bringing Them Home report recommended 54 actions. 28 years later, most have not been fully implemented. The apology has been spoken. The records exist. The survivors testified. And 20,000 children are in care tonight. I'm working on a follow-up investigating the parallel between Australia's stolen generations, Canada's residential school system, and other state child removal programs, including the orphan trains, the Verdingkinder, and the Lebensborn program. Different countries, different systems, one pattern. If your family was affected, in Australia, in Canada, in any country that ran these programs, tell me in the comments. Because the records don't contain everyone, but the people do. The Chief Protector drew charts of disappearing color. He published them after Nuremberg. The color didn't disappear, but the children did.